It's good to be back going down the road with you. We're going to touch upon a lot of things today. Well, Vikings beat the Packers. We're going to touch upon that a little bit later. Everything from deer heads to verdicts today on down the road. In fact, let's start out with the verdict right away. Mark Friese has been my go-to guy for legal advice when it comes to broadcasting in many cases. He's one of the top attorneys in the state of North Dakota, and he works with the Vogel firm. And I talked him into coming in here, so let's get a chance to visit with him. Mark, good to have you back coming down the road with us.
Great to be here, Joel.
Wanted to get a chance to visit with you a little bit about, the Rittenhouse verdict. Surprising?
Not at all. In fact, the day before the verdict, this is one of those cases that has captivated family talk. My brother had called me, said, "What do you think?" I said, "I think there'll be not guilty verdicts." He predicted the same thing. I think most lay people did.
Yeah. I was talking, I've got attorneys in my family, and I've got former attorney general in my family, and I said, all right, what do you think? They said the prosecution didn't make the case. In fact, my daughter feels he was overcharged, that he never should have been charged with murder in the first place. Your thoughts on that?
I think your daughter's right. And I had this discussion with a relative of mine who's law enforcement, and I said, this prosecutor's gone way out of his lane on this. And he said, you got to remember he's working for a boss. And I thought that was appropriate to say. There's a district attorney or a state's attorney giving directives on what cases have to be brought. And that person is usually elected and is getting political pressure. So it's one of the flaws of our criminal justice system is that we turn to the courts and we turn to the criminal justice process to try to resolve all sorts of social issues. And what happens in cases like this where they get overcharged, it really has the opposite effect. It makes us less trusting of the system.
So let's talk about that. You said he has a boss. Say you're a prosecutor. You're a former law enforcement officer, and you're a defense attorney in many cases now. But you've been on both sides of the argument that's been made. If the state's attorney or the U.S. attorney or whoever says you will try at this charge, do you have the ability to say, we can't win? We can't win. How does that work in an office like that?
And absolutely the boss, whether it's the appointed boss in the U.S. Attorney's Office or an elected boss in a county attorney or state's attorney's office, the subordinate prosecutors, the line-level prosecutors, have to follow the wishes of the boss. I would hope that they would sit down and say that we've got evidentiary problems, there are issues, maybe we should look at alternatives. But this was a case where it probably had to be tried. They had to charge something. There are two people that died, one person that nearly died. There, I think, are good arguments on both sides of the political issue, so they probably had to try something. The question is, why did they try the most serious charge rather than shooting for something reasonable to start with?
So you've got a circumstance in Wisconsin where a black man was killed, right? And it starts a riot. And, of course, Black Lives Matter, that issue is right there on the front page of every paper and every TV and radio broadcasts that were out there. And people are mad. They're mad. I think this was the third night of rioting that happened when the Rittenhouse incident happens, when those lives were took. And so, there's all this talk about, whether or not he's a self-appointed riot policeman, whether or not, how in the world do you send a 17-year-old kid into that, what you've seen play out for 2 days, and say, here, take the AR and just go for it? How do you do that?
As the property owner, how do you let a 17-year-old on your property? As a parent of a 17-year-old, somebody who's not even old enough to vote, how do you allow them to be in that situation? Armed or not, I don't want my 17-year-old in the middle of a riot. Watch on TV, watch the news accounts. I don't want you in the middle of this. But those are huge, huge and big political questions and big societal questions. Why do we allow people to become vigilantes? Why do we allow people to self-police? Why do we allow 17-year-olds to have guns? Why do we have so many guns? Why do we have this type of... Those are really great questions, but they're not to be resolved in the criminal justice process. The question that the jury had here was whether Mr. Rittenhouse had a firm belief that he was in fear of imminent bodily injury or death. And that was the question. I suspect that the jury deliberated a lot about those types of things, the same things that we discussed. Why did they bring these charges? How do we fix this as a society or as a state or as a community? Where do we go from here? But they're tasked with very specific instructions to look at whether he was authorized in using self-defense.
So let's talk about the defense itself. Actually, I want to start with the prosecution. there was a lot of criticism of the prosecution, that they ticked off the judge. You could see the judge was ticked off in the actual, not just in recess when the jury was out, but they were, the judge was ticked off. How big of a factor does that play? Because there's a lot of criticism what the prosecution did here.
I've been on both sides of that. I've observed other opposing counsel being the object of the judge's affection, and I've been the object of the judge's affection. It may change kind of the tempo or the way that the case is presented, but the overwhelming majority of those things occur outside of the presence of the jury. So when the judge was mad about the prosecutor trying to get in what we call prior bad acts evidence or trying to get in evidence that had been excluded, he excused the jury, sent them in the back room, and then addressed the lawyers and, of course, the public, because the public has a right to be in court at all times, address that outside the presence of the jury. So I don't think it had a meaningful impact on the jury that they didn't say, well, the judge is mad at the prosecution, so we have to favor the defense. I doubt that they saw much of that, but they may have gotten some subtle clues that the judge tended to think that the prosecution was going overboard.
When you push that, when you get a pretrial ruling and you start picking away on the edges of that, how much trouble can you get in for that?
Well, you could be held in contempt. The worst case scenario, you're held in contempt and reported to the Bar Association or reported to your boss as a prosecutor. And our system is adversarial, right? So each side has lawyers who are advocating for the result that they think is reasonable and just and appropriate. But this is maybe tainted a bit by my defense, my occupation as a defense attorney. Prosecutors are supposed to be ministers of justice. They're supposed to be seeking a just result. They don't win at all costs. They're not to play to win at all costs. They're supposed to stay within their lane, follow the rules, follow the directives of the judge. So I think that this prosecutor deservedly was admonished by the judge.
Okay. What about the defense? Because there's a lot of talk about what would have happened here to a normal person, where there wasn't this huge outcry from gun rights advocates, from people that really were against and taking strong stances against Black Lives Matter. I mean, Kyle Rittenhouse got a lot of money. I mean, he got a lot of money for his defense. And when you start taking, I think it was upwards of $3 million in advance, I mean, the question becomes, can you buy justice?
I think statistics bear this out, and anybody who will give you an honest assessment of our criminal justice process will say justice depends on what you can afford. There's a lot of truth to that. Hiring the right expert witnesses, being able to prepare, being able to set aside months in preparation for a multi-week trial, that doesn't happen every day, and it doesn't happen with every individual. So people with lower incomes, irrespective of their race, have a tendency to have lawyers that are not as proficient and not as well prepared. I think that the criticisms of our system are appropriate in that regard, that we need to look at providing better mechanisms to provide defense to people who are indigent or who can't afford it.
Okay, so you watch the defense do their job and do it well, do it very well, but they're making determinations. How often have you seen, for example, the defendant take the stand? Is that something? Obviously, he doesn't have to, but how often do you see something like that happen?
In this type of case, I think almost universally they have to take, almost universally the defendant has to take the stand. The defense in this case is what's called a true defense, meaning that the prosecution must disprove it beyond a reasonable doubt. So if I back up a minute, if the defendant were asserting an insanity defense or if he were asserting an entrapment defense, those defenses, the defendant has the burden of proof. They have to present evidence to establish by the greater weight of the evidence that the defense applies. With self-defense in Wisconsin, just like in North Dakota, it's a true defense, meaning the prosecution must disprove it beyond a reasonable doubt. So just like the elements of the offense, they have to disprove self-defense. And the test in Wisconsin is whether the defendant reasonably believed that he had no other alternatives, and he reasonably believes that he had to use that type of force to avoid death or serious bodily harm. So the jury is asked to evaluate this from Kyle Rittenhouse's perspective. They have to crawl into his head, consider what he was considering at the time that he made the decision. And really the only way to do that is to put the defendant on the stand to have him explain what he was seeing and feeling and thinking.
So you take a look at the jury and the amount of time they deliberated, and how hard it had to be in this high profile of a case to be there, period. What do you hope, as a defense attorney, what do you hope is going through their mind when you're picking them? When you're looking and saying, "I'll take juror number one." There's got to be an art to that.
There really is, and I think it's probably the toughest part of the case. Lawyers will often say this case is won or lost on jury selection, and I think that this is the type of case. I heard one of the lawyers for Mr. Rittenhouse afterwards saying that Wisconsin juries want to hear from the defendant. Dovetailing on your earlier question, those types of things are explored when you ask the jury, what are your views on self-defense? What are your views on use of force? What are your views on firearm? What would you do if you were in a situation where you believe that you were going to be hurt or somebody else was going to be hurt? How would you react? But the problem is people aren't always honest when they're being selected as jurors.
Really?
No, I mean, they have a tendency to want to answer questions that they think would be the answer that the person is looking for, which is problematic. So you've got to be honest with the jury. When you're selecting the jury, you have to ask for them to be honest, and you have to ask probing questions. But you really never know until people get back in that jury room and start talking about the case and the evidence.
And the reason I said really was because my natural instinct, if I were picked for jury duty on a case like this, is to try to find a way to not get on that jury. Can you sense that as an attorney? Can you feel that individual's doing that?
I ask that question in almost every case. Is there anybody who really wants to be on the jury? Is there anybody who really wants off the jury? And then I'll ask them why. And on a case like this, if I were a prospective juror, I would say the same thing. I don't want to be on the jury. It's going to take too long. It's too emotional. It's too difficult. It's going to be difficult to deal with because the jury's going to have the view that they don't win no matter what, right? There's going to be people that are disappointed with the verdict if it's a not guilty verdict. There's going to be people disappointed if it's a guilty verdict. So they deal with that a lot in trying to go through what they're instructed to do. They also deal with how do people act in the courtroom? How is the community going to view this result? And what is my overall goal?
I saw the defense attorney because there's all these people trying to grab, Rittenhouse now and make him to be their poster child, right? You got the NRA, you've got the QAnon people, you've got a congressman, you've got a son of a former president in Donald Jr. The defense attorney came out and said, "Leave him alone. Leave him alone. Let this kid live his life." Is that normal? Once that verdict comes in, do they see this? Do you see yourself as still advocating on behalf of?
Well, those lawyers have probably developed a close kinship with this young man, having really stood between him and the lynch mob for the last year. So they're going to look out for his best interests. And I think that they're right. Society is going to want to embrace him as a villain or embrace him as a vigilante who brought justice. He's 17 years old. He's impressionable. He was too young to be making these decisions in the first instance or to be put in that position. He's taken 2 lives. He nearly took a third. He's going to spend the rest of his life developing and maturing. Eventually, he's going to realize and have thoughts about how could have I done this differently? What could have I done differently? Even police officers who are trained to use deadly force deal emotionally for a long time, if not for the rest of their lives, having taken somebody's life, even if it's justifiably.
Is using a fake jury the way the defense did here to go through every step of the trial? Is that the norm, or is that something money brings?
No, that's another instance where O.J. Simpson case, for example, $300,000 they spent in that case to try to find the right jury, to hire experts, to do mock juries, to try to find the ideal juror. I've only done it in a handful of cases that I've represented defendants. It's very expensive, it's very time-consuming, and most people can't afford it.
Okay. What about, as you pointed out, the decision to go up on the stand? What about his reaction on the stand alone? I had a legal professor at Loyola on today, and on my radio show, and she said, look, what she found so interesting was that her students thought Rittenhouse was faking. That younger crowd thought he was faking on the stands with crocodile tears. I, a 60-year-old man, saw it and thought, you can't fake that. That's a pure emotion. I mean, how does that play into it with the jury?
There's no doubt that the jurors talked about that, and there were pivotal moments in the trial that had an impact that the jurors would talk about. And I'm guessing that there were jurors split both ways about whether his emotions were real. But as the verdict was being read and you saw how emotional this young man was, that's where I kind of fit into your camp, where I think it was real. This is a very stressful, full of pressure type of environment that this defendant is under. He's being asked probing questions about taking other people's lives. I don't think it's at all atypical to become emotional during that process.
Well, he made the argument that this was never about race. This was always about self-defense. And yet, here's a 17-year-old with an AR who's been asked by the car dealer to come and guard his place, right? I mean, number one, who the heck would let him do that? What parent would take him there, drop him off, and say, go get him? And number two, is there any civil liability there for the car dealer?
Clearly, there is civil liability for everyone involved, right? The car dealer, the people who provided the gun to Kyle Rittenhouse.
That was illegal.
It was illegal.
Yep.
In fact, a friend of Kyle's by the name of Dominic Black is facing charges for unlawfully providing a firearm to somebody under the age of 20. So Mr. Black has possible civil charges against him in addition to criminal charges. The car dealer might. Mr. Rittenhouse himself could be sued civilly for the actions here too. A verdict of not guilty ends the criminal case. It's over. There's no appeal for the government. The criminal charges are over. But in addition to the emotional issues that Mr. Rittenhouse is going to be dealing with, there's undoubtedly going to be further civil lawsuits, further inquiries, and further exploration in the court system. But yeah, there is liability possible for all of those people.
From my personal standpoint, by putting him in that position, we can talk about the protesters, we can talk about the rioting, we can talk about all the damage, all of that. I think that there's a special place in the legal system for them. I hope they get arrested. I hope they get charged. I hope they get found guilty. That's my bias there. But the individuals who put this young man in a position to do that bear a lot of responsibility for where his life is now.
And I go back to my position is I don't know that the criminal justice system is the appropriate form for that. It might be in the civil court system, but I'm a parent of young children as well, and I've got teenage children. There's absolutely no way that my 17-year-old would be carrying a long gun in the middle of a protest. And you're right, there are racial undertones here because the entire protests were surrounding the use of force by police in Wisconsin against a minority. So those who say, well, this wasn't racially motivated, it didn't have anything to do with race, it had everything to do with race. It started because of racial tensions. But the parents clearly have some responsibility and obligation to know where their kid is, to protect their kid from being put into this situation. My child is not going to go to work as an armed security officer without licensing and training in the age of majority.
So would it have been harder as a defense attorney to get your client to a position where he's found not guilty if in fact it was a MAGA rally and your client was black?
I think so. I think that those undertones or those overtones have a tendency to permeate every aspect of our criminal justice system. Statistics and studies show that minorities do not fare nearly as well in our system. The proportion of minorities to majority populations in every city is going to make an impact, right? So when you select a jury, getting a true jury of your peers, people that look like you, have the same background as you, that's more difficult. And without a jury of your peers, it's much more difficult to get the verdict that you think is appropriate.
So something about this case just to me smells like it's going to be taught in classrooms like the one you were in before you went and took the bar. That law students are going to be looking at this case. If you were a professor in front of them, a guest lecturer, and you had all those law students sitting there in that arena trying to absorb what you know after having been in that courtroom as many times as what you've been, what would you tell them?
Well, there would be a lot of lessons, and I don't know where to begin and where to end here. But the points that you've raised already, jury selection, how important that is, whether the defendant testifies or not are critical questions. Whether a case like this should be tried to a jury or a judge, because the defendant could have waived his trial right, his right to trial by jury. And then looking at the instructions and looking at the charges. There are lessons to be learned for defense attorneys and prosecutors here. Did the prosecutor overcharge? Should they have charged lesser offenses? Should the defendant have testified or not testified? Those are big, big questions that I think a lot of exploration in the classroom would be appropriate.
I want to take you back to your days as wearing that badge on your chest. You're sitting there, and as I mentioned, it was the third day of this going on. In the Rittenhouse trial now, when that verdict came in, they called out the National Guard. They had them ready, because if there was going to be a riot afterwards, they wanted to be ready for it. I guess my question is, after at least a day, maybe 2 days of rioting, why wasn't the National Guard there then?
Sometimes,
I know that's a political question, but...
It is, but sometimes the introduction of a show of force makes things worse than it makes it better. Historically, go all the way back to Zip to Zap in North Dakota. National Guardsmen were called out, and it turned into an absolute riot. I think that law enforcement does a pretty good job of moderating and evaluating a crowd and trying to anticipate what type of reaction introduction of additional force is going to create.
Interesting. Very interesting. To me, it still goes back to whether or not they got it right. And that's how we began this conversation, because nobody should go to jail that shouldn't be in jail. And, I went into this trial very biased. I thought he was guilty. I thought that this was, kind of a right wing, get out there, I've got an AR, these black people are doing this. My opinion changed. It did. As the trial went on, my opinion changed. And I would guess that's the kind of juror you'd want.
It is, and we have to remember, too, that these jurors heard every bit of evidence. They heard a lot more than we did. What I've seen was anecdotal in the reports on the news media. And this is our system, and there's no better system in the world. A jury of lay people hearing the evidence, getting instructions from the judge, and applying the facts to the facts to the law and reaching a conclusion. I never criticize a jury's decision. They work very hard. They're committed people. They take an oath, just like the police officer on the street, just like the defendant who swore to tell the truth. These jurors took an oath that they were going to do the best that they can. And it's tough work. It's tough to do.
And it's life-changing work for them, too.
It is.
They'll be talking about this years from now.
They will.
Mark, thank you. I appreciate you coming down the road with us.